Delhi High Court today has pronounced its decision with respect to anti-profiteering provisions. The Delhi High Court acknowledged that 2017 changes mark a paradigm shift in the erstwhile provisions and the laws under the current GST regime. While upholding the provisions of anti-profiteering under Section 171, subsection 1, Delhi High Court held that these provisions pertain to commensurate reduction of prices and these provisions are in public interest. The Delhi High Court has very well and in very clear terms has explained that these provisions fall within law-making power under Article 246 capital of the Indian Constitution. Delhi High Court very clearly provided that Section 171 lays down clear legislative policy and doesn't delegate any essential legislative functions. The Delhi High Court was very clear in explaining and holding that impugned provisions are not price fixing mechanism and hence there is no violation of Article 19(1)(g) and Article 300 capital A of the Indian Constitution. Delhi High Court also held that reference of anti-profiteering provisions of Australia and Malaysia are misconceived. Delhi High Court very specifically provided that no fixed or mathematical formula can be laid down for determining anti-profiteering and hence Delhi High Court held these provisions to be unconstitutional. But there is a big relief even for the petitioners with respect to the calculation for each project, and Delhi High Court held that the passing of the benefit for the home buyers has to be on the basis of per square feet benefit to each buyer, which implies that equal square feet area benefit will be given in terms of the equal area for each of these buyers. So which means equal benefit for equal space would be given to the petitioners. It is also held that it is the prerogative of the legislature that how benefit is to be passed on. Rightly, the provisions do not fix a time limit for which price reduction is to be applied. Delhi High Court has also given finding with respect to Section 64A and has held that this is not applicable, which implies that provisions of Sale of Good Act is not applicable for obligations under Section 171. Delhi High Court has held that statutory provisions cannot be struck down on grounds of possibility of abuse. Delhi High Court did not hesitate to say that with respect to the comparison of taxes in the GST regime and the basket of the erstwhile indirect taxes would go against the intent and objective of the Act of 2017 and hence, according to Delhi High Court, this comparison is not wrong. Delhi High Court has held that there is no vested right to appeal and appeal is a creation of statute. No requirement of a judicial member in NAA has also been addressed by Delhi High Court. Delhi High Court has also held that Rule 124 is in consonance with Article 50 of the Constitution. The court very clearly held that there is no scope for intervention of the government in NAA proceedings. The Delhi High Court also held and provided clear mechanism with respect to 133 rule, and it has held that interest is within rule making power of central government. This means that all of these anti-profiteering provisions would now be subject to the applicable interest if these are not challenged and struck down by the Supreme Court in the days ahead. Delhi High Court has also held that GST collected on additional realization is rightly included in the profiteering amount. Delhi High Court has held that time limit for furnishing report by DGAP is directory and not mandatory. Delhi High Court has also held that expansion of investigation beyond complaint is not ultra vires the statute, and hence, as a corollary to the above, Delhi High Court has upheld the constitutional validity of 171 section of the CGST Act and has held Rules 122, Rule 124, Rule 126, Rule 127, 129, 133 and Rule 134 to be constitutionally valid. So what is the remedy now available to the petitioners? And Delhi High Court has in itself provided that the setting aside of the orders on merits may be a possibility or a remedy. It is possible, as per the Delhi High Court, that arbitrary exercise of power by enlarging the scope of proceedings beyond jurisdiction may have happened, and the authorities may have not considered genuine basis of variation. There could be cases of cost escalation and skewed ITC situations, and these would now be determined based on facts, based on numbers, and hence the appropriate remedy as per the Delhi High Court would be to get these matters listed before division bench for directions on February 8th, and thereafter these matters will be listed, wherein these aspects of jurisdiction, cost escalation, ITC skewed situations, etc. will now be addressed on a case-to-case basis. While the petitioners will have the right to appeal against this order by way of an SLP before the Supreme Court, it will have to be seen that how many such demands will now be dropped based on numbers, facts, circumstances, jurisdiction, cost escalation, ITC skewedness, and things like that.